Order, order. I would like to welcome our guests to this evidence session of the Intelligence and Security Committee's inquiry into privacy and security. This is the third public session of 7 public sessions of evidence taking that we are conducting. We also have a number of private sessions with the intelligence agencies themselves and also with ministers. So we're very grateful to you, gentlemen, for joining us this morning. And perhaps I could just ask you, for the benefit of everyone in the room, to identify yourself just very, very briefly, starting on my right, sir.
Okay, I'm Peter Sommer. I hold a number of visiting academic posts at British universities. Most of my income comes from acting as an expert witness in the sort of cases that you are interested in. I act for both prosecution and defence, obviously not in the same case. I also do a certain amount of consultancy work, including at the moment for the Home Office.
Thank you very much. Professor Raab?
I'm Charles Raab. I'm Professor of Government in the University of Edinburgh, and I'm also the Director of a centre called CRISP, which is a Centre for Research into Information, Surveillance and Privacy.
Thank you.
I'm Jim Killock. I'm the Executive Director of the Open Rights Group, which campaigns on civil liberties in the digital age.
Thank you.
John Boucher, Deputy Chief Constable of Bedfordshire. I was the lead for RIPA for National Policing. I'm currently the National Policing Lead for Undercover and the Deputy Lead for Cybercrime.
Chair, good morning. Assistant Chief Constable Richard Berry from Gloucestershire. I've recently taken up the National Policing Lead for Communications Data. I lead a working group developing cybercrime and digital investigation capabilities, and I also chair the Communications Data Strategy Group with industry.
Thank you very much, gentlemen. We want this morning to be as informal as possible. We have a series of questions covering the issues that the inquiry is looking into, and we hope you will feel able to assist us with your views on these various matters. We felt we might start just very briefly, but with what is nevertheless a very important question, the expectations of privacy so far as a free society is concerned. And we have asked in our initial questions, what is the balance between privacy and security? Some have challenged whether there is indeed a proper question of that kind to be asked, whether they are not alternatives but need to be combined. Perhaps, Mr. Killock, would you like to offer us your thoughts on this, just to open our discussion?
So I think the first thing to remember is that privacy has become an issue for everybody in a way that it perhaps wasn't by default 40 years ago. Everybody has or a lot of people, most people perhaps have a public face that they didn't before the internet, because you may publish and share things. And although that might to some people imply that people are not bothered about privacy, actually it makes privacy more important to them, because as they decide to publish or not publish, to share or not share, or to share with some people and not others, they're having to put the question of their privacy and the extent to which they wish to not use their privacy or to exercise their privacy into each judgment that they make. So when you share your family photographs, in the past you showed everybody your photographs, now you may put them on Facebook. Your children might be in those photographs. Do you decide to share that with the world, or do you decide to only show that to your relatives? So for everybody, privacy is a much more exercised right. It's something that they're doing and thinking about constantly. And I think it's also worth remembering that this does apply to young people. When asked, young people say that things like privacy and bullying are among their top concerns with the internet, not low concerns, as some people might lead you to believe. And it's also been found that young people choose their privacy settings much more than others. On the broader question, I think it's worth remembering privacy is a public good. It's something that we rely on in this society to give rights to journalists. We've had this whole question in the last few weeks about journalist contacts being seen by the police through RIPA powers, and those journalists becoming very rightly agitated about that, because that compromises their ability to research certain things and to speak freely in public. So our privacy has an element of public good. It is not merely a personal right to be balanced and traded off against public security. The other element I think is absolutely critical to think about here, given the kinds of programs we've heard about from GCHQ, is that personal security and privacy are highly aligned. So if there are techniques that are used by GCHQ to, for instance, take over computers or take control of mobile phones or to access networks, these techniques rely on things being broken in software that is generally used by companies and individuals very widely. And that means that if GCHQ are using techniques which involve essentially not fixed problems in software, then they are trading off they're deciding that their ability to sometimes investigate criminals is more important than the general security of people using software, not just in Britain but globally. I'm here talking about use of software bugs to access equipment. So in that sense, unlike targeted surveillance of a generation ago, where you might install a bug in an office to listen to people, GCHQ are perhaps getting access to a computer through a bug they know about to listen in on an office. When they use that sort of technique, they're relying on software vulnerabilities that everybody might have exploited in a different manner by either a foreign agency or by criminal gangs. So there's a really important point.
An opening comment.
Okay, sorry.
We'll have opportunities to go into some of these other issues as we work our way through. Thank you very much. Hazel Blairs.
Yes, it's another fairly general question, and the ECHR provides that privacy, the right to private family life, is not an absolute right, it's actually a qualified right and subject to constraints. I'd just be quite interested in your view about what the qualifications are on the right to privacy, and whether there are circumstances in which an individual's right to privacy can be trumped, if you like, by the need for collective security of the nation as a whole, and where that on that spectrum some of those rights might lie. And I think I'd like to ask perhaps the police to comment on that, interestingly, just to set our discussion going.
Thank you. I'll begin, if I may. Firstly, I agree with a lot of what Mr. Killock has said, and human rights is enshrined in our system, and we're very proud of it. And Article 8, right to privacy, has been adopted. But as Mr. Blairs points out, that is a right that will be foregone or trumped if people behave in a manner that threatens the safety of people. There was a case not that long ago, the Killock case, which, to summarise it, the judge felt in that case that when somebody came out their front door to peddle drugs, they forgo their right to privacy, and that the police were able to legitimately watch that person conduct those activities and record them. I think the important thing to remember here, and it is a very difficult question, and it is not necessarily in black and white, is that the game has changed. Communications data has, and the technology has exploded in a way that certainly I would never have forecasted, and I don't think anybody in this room would have forecasted. And as a long-standing detective, we would focus our efforts on collecting evidence against people in a fairly rudimentary and basic way. And it wasn't technically challenging because of the world we lived in. It is now really technically challenging. And we need to balance the right to privacy and sharing of photographs and images with the need to protect people from dangerous people, paedophiles, terrorists, murderers, who don't have the same values as I'm sure Mr. Killock or I or members of this committee. And that's a really difficult thing to do. I think the important thing, and there is a real link here around the right to privacy, we respect it. And sometimes I think there are questions that we can't answer and need additional oversight. We need additional help, actually. The example might be undercover, and where the statutory instrument that came in January says we need the Office of Surveillance Commissioners to pre-authorise undercover operations at 12 months. Whatever it might look like, I think comms data and the access to it for law enforcement agencies and intelligence agencies has got to be made available in a way that we can still protect society. But it's got to be made available in a way that society is confident that we're doing that properly. And whatever measures need to be put in place to do that, whatever changes need to be made, and I suspect that's more investment on our side, we would fundamentally support, because the right to privacy is no more important to any organisation or anybody sitting here than to the police. I think that sort of captures where we are on this issue.
Fiona?
So I should just to complete this triumvirate of questions ask the professors about a point that I think Jim Killock has addressed, but I would be interested in your view, which is to do with has the extent of the internet actually changed people's expectations of privacy with the way that the information is shared at the moment? People use supermarket cards and so on. Does that change their expectations of privacy?
The answer is in two ways. The answer is yes, there's just a lot more information available in ways which would have been extraordinarily difficult to forecast 10 years ago, maybe even 5 years ago. When you're talking about expectations of privacy, privacy isn't just a single solid element. People might be willing to concede a certain amount of information when they go into their Tesco store and use a rewards card or whatever it's called, because the benefit to them is that the store in future is more likely to have in stock the items they actually want to buy, and every so often they might get a special offer. It doesn't extend any further than that. Perhaps the same might go for Amazon. The great threat of giving your information to Google in return for all of its wonderful indexing is that you receive rather more advertisements than you particularly want. But those are relatively limited. There is an extent to which, if it's a commercial entity, public opinion can change things because it's fairly obvious what they're doing, and you've had instances of Google and Facebook and other people collecting perhaps more information than their customers felt comfortable with, and organisations have then drawn attention to it, and the Googles and what have you, Facebooks have then withdrawn particular facilities. When you're talking about collection by the police and particularly by the agencies, those mechanisms don't exist. The second thing I wanted to raise is I'm not sure how far this sort of very sort of high level, I can see why people want to ask the high level, how do we balance? Is there a magic formula for balancing? But in practice, the way things appear is as a whole series of individual decisions about necessity and proportionality. And if you, are a law enforcement officer, and I've had the opportunity of looking at how the police handle communications data, looking at it in considerable detail, then you can see there is a fully audited trail for every decision that they make. It's computer it's available, always supposing that the commissioners are doing their job properly. They can see all of that. If there is a prosecution which follows from it, that material is then disclosable under the Criminal Procedure and Investigations Act. The real problem about that is how all that applies to the intelligence agencies, whether you've got that same sort of audit trail which can be tested. So it's these sort of simple questions, which one fully understands, tend to have rather more complicated answers because the situation is more complicated than you initially think.
Can I come in on this as well? I think that there's a lot of conventional wisdom that people don't care about their privacy anymore because of technological changes and the internet and so on. And in fact, I think that assumption is a bit of a myth, that people do care about their privacy. They also care about security, but they define it in many different ways. And as has been discussed, privacy is a very complex concept. It has many facets, many domains in which it is exercised. And likewise, security is not a very clear concept, much less national security. When you ask, it's very difficult to find out what people expect or think about it, because, first of all, there have been hundreds of surveys done about people's attitudes towards privacy and so on. And as part of a research project called prisms, not prism, which is, I think, something else in this context, but prisms. We have looked at quite a lot of surveys of people's attitudes to privacy, and we have done a survey ourselves of some 27,000 people across Europe. If you ask people, do you want privacy or security, and how would you balance it? That's not the way to ask the question. You have to be very crafty in asking questions about different kinds of contexts in which it may be important, in order to tap what it is that people are concerned about, what fears do they have, how do they regard different kinds of privacy, privacy from exposure to CCTV, privacy on the internet, privacy in terms of body searches at airports, and so on. And those are different facets. And if you ask the questions in a sophisticated manner, you do get sophisticated answers which suggest that people don't make a trade-off, they don't do a balance, but they look at things as they come, and they want both. And I think there may be some increasing evidence, although I couldn't supply it on the spot, that since the Snowden revelations, there are more people who are concerned about their privacy on the internet and in terms of other kinds of communications. So that's maybe a long-winded way of saying that it's a very complex and subtle area, and to ask the question, how do you balance security and privacy, is asking it at a level which doesn't really get us very far.
Charles, wouldn't you agree that one of the problems of running surveys is it depends what precise questions you're asking and what has been in the news immediately beforehand? If there's been a terrorist outrage, it'll incline towards security. If there have been complaints about police abuse, then it'll incline towards privacy. People don't think about it terribly coherently. Indeed, even for academics, it's quite difficult to think about it.
Thank you. Assistant Chief Constable, I think you wanted to...
Yes, if I may, Chair. I mean, I'm really intrigued by all of these debates around legal structure and oversight and how we interpret these really, really complex issues. One of the things that, and I appreciate that as a police service, we're kind of guest at this committee. We're not, you scrutinise the intelligence agencies rather than the police. But perhaps if I could share something that we're considering actively at the moment, and it's around the Police Service Code of Ethics. On the 2nd of July this year, we held a masterclass of practitioners, officers, academics involved in ethics to try and work through some of these issues and how we could demonstrate almost a digital ethical accountability to the public, to go back to policing, this notion of policing by consent. Whilst we haven't achieved the answer there, one of the products of that thinking and that workshop was to look at some kind of ethical governance capability to ask and explore and probe some of those difficult questions. And I would make the analogy with medical research, the fact you have ethical panels that probe and ask those really difficult questions. And when the law isn't quite clear, when procedure isn't quite clear, that's a kind of safety mechanism to fill the gap, and that's something that we're looking at developing with the College of Policing and trying to take that forwards to.
Sorry. Chief Constable, because we had a public session yesterday,
yes.
And the idea of a code of ethics in a similar way for
yes.
the agencies was mentioned. Are you sharing this work that you're doing with the agencies?
Not yet, but we would be delighted to do so. We're very much working with academics on this, so we'll very much be guided by them. But it's a space that we haven't filled, and in terms of public trust, transparency, accountability, and to be able to answer those new questions around consent in the digital age, I think it's perhaps part of the solution.
Thank you very much. I think we perhaps should now move towards the capabilities that are available to the intelligence agencies and to others. And could I ask Julian to open up on this question, particularly with regard to targeted intrusion?
Yes, we'll presently be coming to the much more contentious area of bulk data and the morality about surrounding that. But what I want to ask is about targeted intrusion involving the sacrifice of an individual's privacy as a result of reasonable suspicion that they might pose direct threats to the UK. And under those circumstances, do you think that it is proportionate for the intelligence agencies to investigate individuals and for those investigations to intrude on their privacy by the use of such methods as interception of communications, following them, eavesdropping on them, and other intrusive methods?
May I begin, Chair, on that one? First, the distinction, and Richard's mentioned it, we are guests here, and there is a separation between the intelligence agencies and policing. And that's important because a lot of what was talked about a short while ago, interpretation, we often rely on the courts to do that. We rely on judges to interpret national security, privacy, have we behaved properly? I think, and I have some experience in the counter-terrorism arena as senior investigating officer for a number of investigations that often began with intelligence agencies' development of information. And without that development of information, the subsequent investigations that we conducted would never have commenced. And in the reality, people's lives would have been lost. I don't think the question is whether it should happen. I think it's how it should happen and the measures to be put in place that we have with oversight through the surveillance commissioners and other bodies, Interception Commissioner and the courts. We've got to provide the reassurance for people in this room and the public that the intelligence agencies are held to account and only examine data where there is information to suggest that there is a threat and that they are accountable for their activities. And I think that's the gap that we just need to achieve the reassurance. And if we can, I'm sure we can design it, but it's not necessarily correct at the moment.
Sure, the answer to your question, it has to be a very simple yes, but what you want is the audit trail. You want to have a record. It's pretty easy to do these days because most people operate on computers. Computers create records. You want an audit trail which says this is our investigation. We think it is necessary, proportionate to get to this next stage. And if you are carrying out an ongoing interception, then you need to be able to keep a record of all your actions and why you need to continue doing it. One of the things that came out of the HMIC report on covert policing, I know we've got appropriate representations on this table, was a complaint that there was insufficient supervision of what was going on. Now that related to the police. It's a lot easier, as you heard down the other end of the table, to do it within the police, and the real problem is how you do it in terms of what goes on in the intelligence agencies, and there is a direct clash of evidence. You've got assertions by representations of GCHQ, both in public and in private, oh, it's all very robust, there are lots of systems of authorization, and you have then the Snowden documents, which no one has actually said are forgeries, which seem to contradict that. I don't have any easy way of resolving it, but perhaps that's something you as a committee can be doing. It seems to me the audit trail, which provides the justification at every stage under the necessity of proportionality tests, is the way forward.
So far we haven't had any witnesses saying that privacy is an unqualified right, but I did want to give Jim the opportunity to have a word.
I think, obviously, I'm going to agree that, yes, targeted means of investigating people who are thought to be engaging in very dangerous activities is absolutely the right thing to do. And I'd go further to say that for most civil liberties groups, it is a strong preference that that is what the agencies do. That is to say that civil liberties groups want to see criminals and terrorists investigated because they're suspected of being criminals and terrorists, rather than relying on bulk data collection and analysis, which effectively involves everybody's data being looked at and analysed. So For us, I think there's a strong preference for this kind of approach. I think where we get into difficulty is what I was alluding to before, these questions of when the investigative techniques then start relying on using vulnerabilities that are known about everybody's equipment.
Yeah, you made that point. Very good. Thank you.
Dr. Lewis, I think you said in the scenario you gave that this was authorized and warranted. Did you not?
Yes. What we're talking about is purely the question of whether or not intrusive measures, properly authorized, are permissible, even though they infringe an individual's privacy, where there is specific evidence and intelligence to suggest that the individual poses a threat.
Yes, I wouldn't disagree with that. I think it's important to apply the necessity and proportionality tests. And you mentioned a number of intrusive measures. And it might be a question of whether you need that whole package of them and whether each one has to be assessed in terms of its necessity and proportionality. If you can get by with 2 out of the 3, then that's better than 3 out of the 3.
I think given the nature of the answers, we won't need to spend too much more time on this particular area, but Mark and Robin, I think you have particular
just
points.
very briefly, I just
You don't
wonder
need to.
specifically you had any concerns where you're looking at someone whom the intelligence agencies regard as being a threat. Do you think that any of the intrusive elements we've discussed would not be justified? Where would you draw that particular line? I accept from what Professor Raab said that ultimately these are often cases that are deemed by the facts in a particular case. But is there any sense that you have of particular levels of intrusion that would never be acceptable or justified?
Well, perhaps it could be that if you're not only being intrusive on the particular individual who is under suspicion, but on his family, let us say, then that might raise other kinds of questions about whether that was legitimate and proportionate, because inevitably it isn't simply a single individual, but a range of domestic contacts, and then going further afield, even into other, scooping up information about others with whom that person is associated, would, I suppose, raise additional questions about whether it would be acceptable.
I don't think it'd be a question just about technology. The overall tests are necessity and proportionality, and I don't think you would limit yourself to any particular technology. Some technologies are obviously more intrusive than others, but the overall test stands. I don't think you want to just sort of set up a rule that, whatever you do, you mustn't sort of hack into somebody's computer remotely. There may be justifications for doing that.
Thank you. Let's now move to the more difficult question of bulk collection. Michael Lothian.
It's been quite interesting. Right across the board of this inquiry, there's been an acceptance that the right of privacy is qualified, as it is under the ECHR, and that where reasonable suspicion is there, then direct targeted techniques are permissible. But the interesting point that arises from that is that where you know somebody is likely to be about to commit a crime, then it's simple, you target them. But where you are looking for people who might be about to commit a crime, but you can't prove that, and I will give you the suggestion, for instance, of terrorists or criminals, organised crime, who go to great lengths to conceal what they're doing, largely through use or misuse of the internet. How do you then find them if you're not allowed to collect data on a wider basis than just on a targeted basis?
Well, it's a question, I suppose, in part, of how you define bulk collection. It's a term that we all use. I'm not sure that it has a particular definition, and whether bulk means everything from everybody, or whether it means simply more than one or more than a very small number. And so one would need to judge the legitimacy of it, and indeed the effectiveness of it, by saying, well, how bulk is bulk? There may be ways, and I'm not a mathematician or a technologist, but I understand that there are ways of collecting more data than you need, but not bulk in the sense of absolutely everything, in order then to be more precise about whom you target. I'm also told that there are ways of working outwards so that you don't specify in advance that we need to have everything or 2/3 of everything in order to target. And it may be that those are the areas that one ought to investigate with some technological expertise about how you can do these things to cause the least amount of intrusion on not only privacy but other kinds of human values and freedoms that may be at issue in that circumstance.
Assistant Chief Constable.
So if I may, thank you. I think there's a couple of things that have come out for this meeting. First of all, there's something around standardising the lexicon that we're using. I did make this point to Mr. Anderson recently at CDSG that when we talk about bulk, what do we mean? When we talk about passive collection, what do we mean? What do we mean by analysis? There's something around the need to all talk the same language, which would be really, really useful. But I can answer perhaps some of your inquiry from an organised crime perspective. I had the fortunate position of coordinating an operation called Pentameter 2, which was a UK-wide action against human trafficking for UK sex markets. And during that inquiry, we processed intelligence in bulk to discover the organised crime networks that were operating in the UK. As a result of that, we could understand all of the networks that were acting, how we could interdict on those networks, all of the networks we knew about, how we could interdict on those networks and trace them back as far as Macau province in China at the time. So there is a need to have bulk analysis from collected data, and 75% of the data that we used in that exercise was communications data. So very targeted, very, very bulky in terms of an exercise, but absolutely allowing us to get in front of criminal acts and interdict on those criminal networks.
I mean, are you able then to answer Professor Raab's question as to what is bulk? In that case, how large was bulk?
I think we need to define it. So I've had conversations with colleagues around, we use the term fusion of data, bringing data entities together. I think there's a need, certainly from a police service perspective, to create some tiers of what we call bulk, what we call fusion. But that work is there to be done.
Mr. Killock?
If I may, I think that the simple distinction is between bulk and blanket. And where the courts, for instance, have had a problem is not with bulk, but with blanket. What they've said is you need reasons, you need specific instances, you should look at why you need that evidence base for your investigations. But if you simply have no reason other than it may be useful in the future, then that is not permissible.
So very briefly, I think there's a danger. I think police officers sort of said it in an earlier response of confusing the police procedure with the intelligence agency procedure. In the police procedure, when you're talking about bulk information, it is the comms data which is available. In practice, what happens is the comms data is held by the internet service provider or the telephone company, and it is released under procedures set out under Section 22 of RIPA. It's a clear separation and a clear audit trail. We were talking about the intelligence agencies. As we understand it, they have that information and possibly intercept information, and that is all within their own control, and that is then a quite separate set of problems.
Thank you. Hazel Blair.
That's the very issue that I want to come to, and there is a distinction, and I'm grateful to Professor Sommer for that. The agencies have sometimes described it as either looking for a needle in a haystack, or then we've gone further and talked about the hay field. But the essence of the argument is that they need to have all of this bulk collection, if you like, which they do not look at indiscriminately. So there's no indiscriminate surveillance. And what they say is incredibly helpful is to have all of that material and then to be able to conduct targeted searches against that material on the basis of patterns of behaviour, links between people, to enable them to develop targets. So these are people about whom they don't have suspicion. They don't fall within the definitions of being able to get 8-1 warrants and go against them in that way, but it's developing targets that could well prove to be plotting and involved in terrorist arguments. And it's been very interesting from people's very different perspectives. So I think, Mr. Killock, you said this kind of bulk activity involves everyone's data being looked at and analysed. And I think it's quite important to say there's a difference between bulk collection and then what happens in terms of analysis and interrogation. Now, some people take the view, and I'd just be interested in your view on this, some people take the view that collection in and of itself, irrespective of whether it's interrogated or analysed, is a breach of privacy and one that goes too far. Other people take a very different view on the basis that if it works, then that's an intrusion worth accepting. But some people take a very principled view that the privacy issues bite at the point of collection rather than analysis or interrogation. I'd be interested in your view.
I think that's been the clear view of the courts. That's what happened with DNA database, for instance. The point was the collection of the DNA was an intrusion in and of itself. It wasn't the point that the police or the courts decided to go back into the database and pull it out. It was the fact that your data was in there in the first place. So that principle, I think, has been discussed. It was similarly discussed, I think, with the data retention directive by the CJEU recently. The point is it's an intrusion. It's not to say it's the worst intrusion or the only intrusion that can take place, but it is an intrusion. It therefore needs justification why you're holding this data, and they suggested that needs to be specific threats, for instance, in the case of data retention. The question is, I think, when you are talking about, or when the agencies are talking about pulling out particular pieces of evidence from this field of evidence that they've gathered, this needles in haystacks kind of argument, it's not, the computers that do the analytics they have to look and analyse, profile and rank everything in it. So it is not really possible to say that certain individuals are not looked at. The computers are having to analyse everybody. They will profile people and decide that that's 80% interesting, the threshold's 90, so we won't report that. But then the agents perhaps adjust the parameters. Maybe you start using Tor or you start encrypting some of your emails, and that puts your ranking up, and then the same information is then presented. So the fact, I think, is that you can't really say that in order to produce the needles, you are not looking at lots of the data. The machines have to look at all of it, and they will profile everybody for however long and for whatever reasons. They will do that in order to report back results.
Two sorts of searches, I think, which one ought to, with danger of getting confused. One of them is when you are trying to sort of build a general profile of what Mr. Terrorist looks like, and you are going through a huge amount of data, and they're saying they have these particular characteristics, then everyone who meets those characteristics is therefore going to be of interest, and we ought to be inquiring of them. And the danger there is of what's called the false positive. Same sort of thing that you come across when you use Google. You type in some search terms and it tells you it's found sort of 50,000 references, but actually when you look at it you see probably there are about 2 or 3 that are relevant. In terms of an intelligence agency using those techniques, which are often promulgated, the danger is if you get the false positive, then suddenly you've lost the opportunity for the job. You're on the no-fly list, and you might get arrested even if you're later on released. There is another sort of search which seems to me a lot more acceptable, which is when you are saying, right, we've been investigating a group of people, we discover that they've had a number of contacts, we don't know very much about them, but we'd like to know what those contacts were doing in the reasonably recent past. That's classically how comms data is used by the police. Now, there are software tools which are available to assist them doing it, but they are radically different exercises, it seems to me, in how it's being used. And again, so I'm banging on about this audit trail, which where people are setting down what they're trying to do, and that, if that exists, then that seems to me to help the inspector. It also gives credibility when the inspectors say, we've looked at these sort of things, we think the decisions are roughly right, and then back to what I suppose is going to be your last item, Chairman, is oversight. It then makes the oversight more credible as well.
Thank you. Can we, Mark, and then Robin?
The transparency of that audit trail to which you refer may give some succour to the public that things are right. Is there not also a risk that too much transparency about the mechanisms and the manner in which either the police or security services are going about their legitimate business of trying to protect security, doesn't that actually also lead them to potential terrorists or paedophiles or others being made well aware of those sorts of mechanisms and therefore going underground and therefore
I think you can demonstrate the principle of the existence of the audit trail and its robustness without necessarily showing people the individual entries into it. And if people can see that over and over again an investigator is having to explain to his colleagues what they're trying to do, the police, the investigating officer has to get the agreement of his local SPOC, single point of contact, and then the SPOC goes to the senior designated officer. All those things are properly recorded, and then the access is recorded. You can demonstrate all of that without showing you the individual entries. That would give you some level of comfort. And I don't see that that gives away anything very much, because people know that data is collected, and that's all that the process is telling you.
But the broader argument about the concerns of the perhaps arguably irresponsible actions of the Guardian in going into great detail about the Snowden revelations was that precisely that it gave rise to public knowledge, therefore to a wider field of people, about the mechanisms that were adopted by security services. And as far as security is an albeit rather a big jigsaw.
If I can answer that question.
Bits you understand that others there. Actually, it would be interesting to have some for our police brethren, whether they have any thoughts on what I've said, what's just been said by Professor Sommer.
I think there's some validity in what you say. We know that terrorists who we capture, prosecute, convict, share all of the disclosure which we provide with each other. They have their own operational security debrief to think, well, how did we communicate, how did we operate, how did we get identified? And they are very sophisticated in doing that, which makes our job ever more difficult. So there is some validity, I think, in what you say.
Sorry to disturb you. Have you noticed specific changes over the last 12 months, 3 years, 5 years? Is that sense that people are getting more sophisticated about the way they're being looked at becoming a much bigger problem?
Without a doubt, and I can give you, probably not in this forum, some details around what we've seen of how communications that we became able to monitor became understood by the terrorists, and then they changed that way of communicating, because that was the way we managed to identify the fact that they were planning an attack in the UK. So that is a very valid position, and that causes me huge concerns. But we go back to comments I made at the beginning of this, and Mrs. Blair's comments about the retention issue per se that Mr. Killock dealt with around privacy. So just collecting that data. The way data is now collected, both for the agencies and ourselves by companies, the way the technology has developed, means it's not as simple as it used to be that we're going to get that phone billing, can we have access to that phone billing? They don't collect data in that way anymore, and the way they used to collect the data was simply based on how they would charge us. They would collect data so they could say, Mr. Boucher, you owe us so much money for your phone bill this month. They don't need to do that anymore. So we are then losing visibility and access to some of that communications information, and that's a game changer for us. Because of some of the techniques that are available and the data collection and the metadata, which is enormous amounts of information, because of the way these communications are collated, are integrated. You have to actually examine and explore, as Mr. Killock explained, lots of people's information and lots of data to extract what you need. It is a fundamental requirement that we have that data to examine. To do that, otherwise we will not be able to, the security services will not be able to keep people safe. What we need to be able to do is demonstrate absolutely within the security services and the intelligence agencies that they can do that in the proportionate, justified and necessary way. That they're not, it's just, and some of the language in the media is really unfair and misleading. It's not a snooper's charter. And if some of the mechanisms that are required to do that through technology mean that they do look at some of my phone billing gets hived off because a terrorist had contacted me in some way, then I think the public will accept that trade-off. No one's looking at them, but there has to be, if you like, a filtering of data to get the information about communications. Is there patterns of communications with certain areas of the world that are hostile to us at the moment that might indicate, and our threat level has now gone up obviously from substantial to severe, that there is a plot against us. And we have to be able to do that. And the way, and it might sound quite dramatic,
bring this answer to a conclusion.
The way I was going to describe it, if we don't, it's a bit like feeling that fingerprints are being taken away from us, the use of fingerprints in investigations. Because the world has moved on in how we operate as investigators and intelligence agencies work. And we have to be able to be given the tools to do the job, albeit with the right oversight. And that's the key, is the oversight.
Thank you very much. Thank you. Final question in this section, Robin.
Right, just want to be quite clear about the witness's view about bulk collection, or what Mr. Killock has very helpfully called blanket collection. Some of our witnesses have said that blanket collection, under any circumstances, is unacceptable. Now, the way in which blanket collection is normally operated, well, it's universally operated, is subject to very, very great filters, where it narrows it down to an infinitesimally small potential of targets that might be interesting. Now, I think you could call that targeted investigation, because it only picks out a very small number of subjects. If it is operated in that way, is it still unacceptable?
Yes. I think the agencies need to perhaps take the kind of approach that Charles Raab has thought about and suggested, that maybe the collection needs to be thought about to be narrowed down. The problem is that for everybody, if all of your data is collected and analysed, then you start changing your behaviour. You start thinking about why is my data being collected? Why is the state interested in all of us? What are the potential things that are going to happen there? And in any case, I think part of why this has happened is rather to do with just the design of the internet. The fact that when the internet was designed and when it was rolled out, people weren't thinking about the fact that people might intercept the data along the way. And the result of that has been that the companies themselves have started to change their behaviour. So it may not be that this is such a great technique to simply harvest everything. That may not be quite such an available technique. It may be that in the future the agencies have to go back to the companies. If you want Facebook's data, it's been encrypted user to user, so you have to go to Facebook. Actually, I think for everybody that's a much better way, because you can keep the accountability. You know that who's going to what company. The sort of transparency that Peter suggested become possible. It is a much better way of behaving. It also makes everyone more secure in their everyday communications.
Thank you very much. Now let us move on to legislation.
I think Mr. Berry just wanted to say something.
Well, briefly, if you would, please.
If I may, I do caveat what Jim has just said. In relation to cybercrime, because of the volume, velocity and variety of criminal behaviour on the internet and the ability to transmit lots of malware in a short space of time to targets, and I can give an example of child abuse imagery. I've recently dealt with 500,000 IP addresses visited that particular content that was maliciously put into a website. Because of the power of the internet and cybercriminality, if you don't have some form of blanket coverage across the internet, then that criminality will be very, very difficult to intercept and deal with.
Let us, if we may, move on to the question of legislation. RIPA and the other legislation under which the agencies operate. It has been suggested that RIPA is an analogue law in a digital age, that the legislation itself is virtually incomprehensible to most people. Could I ask not just whether you think it needs to be modernised, but if you do believe that, what are the particular changes or improvements that you would wish to recommend? Professor Raab, would you like to open up in this area?
A little bit, Chairman. I think that the REPA Act is generally acknowledged to be a bit of a mess in terms of the different parts of it, the different requirements for authorization and for warrants and so on, and that therefore it is not entirely clear. And I think that this has caused confusion not only in the public, but also amongst those who have to operate within it about what are we supposed to do under REPA. So I think it possibly needs to be streamlined and reinforced and also made much more clear so that the kinds of activities that go on under REPA can be regarded as acceptable, can be regarded as something which maintain or promote public trust and confidence, rather than it being seen as simply a kind of general act which allows all kinds of things which it ought not to.
Professor Sommer?
So I think that's probably a short answer on that.
Thank you.
I think one of the main problems is that it's no longer easy to separate communications data and content. I sort of generated a short note for you. I don't know whether the clerk has distributed to that. I'll just sort of orally sort of say roughly what I was saying.
Well, please, if it's in writing, we have seen it. So
okay,
well, rather short of time.
Okay, I mean, essentially, look at a typical Facebook page. Ask yourself, how do I apply the definitions? It's obviously got content and communications data together. If you can't separate them out easily, if it can't be done technically, bearing in mind that the authorization regimes and the admissibility regimes are completely different, at that point you have to say we need to abandon this altogether. And my own view is I would prefer to see a sort of electronic, an interception of electronic data in transit provision, which would cover subscriber data, traffic data, communications data, as it appears in RIPA, but you would then see at the top level content. I think it would be a great deal easier. It would mean that you would have to make content admissible, but I think the time is long gone when there's any argument against, sensible argument against trying to keep it inadmissible, and you then also look at the authorization mechanism. And I think that's probably the most fundamental change in terms of, the particular remit of your inquiry.
Thank you very much. Julian Lewis?
Yes, I think we've largely covered the questions of lawfulness, necessity and proportionality, but just for the sake of the record, these are the provisions that apply under the European Convention on Human Rights and the UK Human Rights Act. And these provisions and principles, I basically want to know whether you're generally satisfied that the lawful purpose requirement, that means that interception has to safeguard national security, including relating to our economic well-being or the prevention of serious crime, that is a legitimate reason for interception of communications, and that the principles of necessity and proportionality are sufficient safeguards when applying this legislation to the practical question of intercepting someone's communications. Perhaps, Jim, you'd like to start.
Well, I think the human rights principles are exactly the right place to start. And what I would really like to know from this committee and also the government is, are they prepared? Are they going to recognise that when judgments are made in the next year or two about some of these practices? I think the one bit that you missed in your description is the question of the quality of the law. Can we, by reading RIPA, understand what is going on? Roughly speaking, do we understand the rough kinds of capabilities that the agencies are likely to have, what kind of things they might do? And I think it has to be said, it is not clear from RIPA that blanket collection may be taking place under warrants. Just from that point of view, never mind any other, I think RIPA needs to be reviewed to make that absolutely clear. And then in particular, there could be a public debate about whether that is acceptable or not. If I may just digress a second, I think part of the reason that the police and others want blanket retention, it does seem, is because of this explosion of the sources of data, that is not going to get smaller. It is only going to get bigger. The places that you might find data will get more and more and more, and they are not going to reside in a single place. And the idea that we can go to the telephone company for the records, frankly, is as imaginary as to think that the BBC is going to provide all of the television in 10 years' time. It just isn't happening.
Thank you. Michael Lodin.
Yes, looking at RIPA and the system for granting warrants, both under 8.1 and under 8.4, there is a distinction at the moment between 8.1 and 8.4 in terms of external and domestic. And there is a lower threshold level for intercepting communications involving a person or an entity overseas. First of all, I wondered whether you feel that distinction is valid and should continue. Secondly, under the same regime, agencies may need to cast a broader net in circumstances of looking overseas, because they may not be looking at individuals, they may be looking, for instance, at groups of people or categories of people or even geopolitical areas. Do you think that is a significant factor in the way that RIPA should operate?
It's significant. How far you can set it down and make it a legal issue, I'm not sure, because you need to sort of then say what sort of evidence is going to be available. One of the big problems about sort of overseas stuff is that you can have, under the user agreement, the Five Eyes agreement, you can have an exchange of information between agencies, and if there's any sort of worry about, we're not going to provide direct intercept data, but we're going to provide an interpretation which is almost as useful. At that point, I think you are sort of successfully evading any sort of form of law that exists at the moment, and I'm not sure what any new law would look like. It seems to me at that level you're no longer talking about trying to give protection to the public in terms of a legal framework. You would do it in terms of an oversight framework, and that might mean things like sort of inspector generals rather than with extensive resources, rather than, and I'm not trying to be sort of gratuitously rude to you, part-time parliamentarians with relatively slender resources.
There are full-time parliamentarians you might like to bear in mind.
But you have a constituency to look after, I believe.
Thank you very much. Robin.
My question relates to communications data, and Mr. Boucher has spoken about how important this is to the police. But of course there has been some criticism very recently about the way in which the police have used their powers under RIPA, particularly in getting access to journalists' telecommunications records in the case of investigation of the Plebgate and the Hune cases, which some critics might say where crime was being investigated, but it wasn't serious enough crime to justify this degree of intrusion on privacy. Now, in a consequence of that, it's been suggested that it's not enough for this authority to be exercised within the police, because the police have been, as it were, authorising themselves to do things which are excesses, and some people might even say amount to abuses. Could I have your comments on that, and in particular whether RIPA needs to be revised in this respect?
Thank you. Yes, of course, sir. I mean, on those two particular cases which have been in the press, and this links to a comment earlier, I think there's been a lot of misinformation in the press. And I am a great advocate for the statutory framework of the Investigatory Powers Tribunal to investigate whether there has been any wrongdoing or inappropriate use of RIPA. What we seem to be doing at the moment is having trial by media, and there are interested parties, of course, in this. I am aware, and I've spoken to the senior officers responsible for managing those cases. They feel, and it will be wrong for me to talk about individual cases, but I think they feel confident in the way the responsibilities were discharged, and I think we need to let the statutory framework take its course for those matters to be properly investigated and not on various pages of newspapers, for then any findings of inappropriate behaviour or absolutely acceptable application of the legislation to come out. So, you know, we have got measures in place to make sure that we behave properly, and they have been instigated, and I think we just need to give them an opportunity to fulfil their responsibilities. The thing on RIPA, and I was the RIPA lead for 2 years, the legislation, you know, 2000, it was written based on society in the 80s and 90s in many ways. And I spent an inordinate amount of my time speaking to barristers for legal advice, as did other interested parties. So Jim and colleagues at this table will be going for their own legal advice to understand the interpretation of that legislation with how we live our lives today. And frankly, I think a lot of that is completely unnecessary because the legislation isn't fit for the way we now live our lives and the communications challenges that we have. That said, Parliament gave us some simple principles to apply, which we always fall back to, around necessity, proportionality and justification. And we take real care in looking at Article 8 and collateral intrusion. So the principles are sound, but the legislation doesn't fit the challenges we now have in society. And I would encourage that is looked at in the future, so we don't spend unnecessary time trying to interpret things that the legislation was never written for.
Thank you very much. We've just got about 12 minutes left this morning. I want to have some opportunity for discussion on oversight and transparency. George, would you like to open up on oversight?
The system as it stands is that ministers determine and authorise the activities of the agencies. It's audited and reviewed by commissioners who are have a judicial background, and any complaints against that system are heard by a tribunal made up of judicial figures as well. I wonder if you could comment on each of those. I know Professor Sommer referred to oversight earlier. Do you think each stage in that process is right as it is, or if not, what should it become?
I think, and it happens quite a lot, I think, here in this country. We sort of set up institutions and then we don't resource them adequately. We have, an information commissioner who's has very, very slim resources, and I think the same appears to be the case of the commissioners. So, as a structure, if you gave them more resources, and if the individual commissioners were rather more forthcoming in public, it could probably work. Notice that the individual commissioners very, very rarely stray into the public. I don't see why they shouldn't be able to explain rather more about what they're doing in terms of principle, because just seeing somebody and asking them some sort of questions. And although I think there is, Sir Anthony May's most recent report is a welcome departure from that. If you read it, it just looked too much like a sort of a clubbable sort of slap on the back. Oh, these are terribly good sort of chaps and chapesses doing very dangerous work. There are a few sort of slip-ups, but we've sort of rectified them. He may actually be correct in his findings, so the strong suspicion is he's not looking at enough material in order to form a view because he hasn't got the resources, and the tone is all wrong. He's there as an auditor, and the auditor of a company, you don't want to go along and say, oh, they're wonderful people and it's a wonderful product. What you want to know is, are they keeping their books square? And to come back to this thing I've been banging on in most of my remarks, it's the quality of the audit trail which is available. If you have the audit trail, then they're able to carry out proper inquiries. So being able to explain what the audit trail is, plus having the commissioners or some substitute for them being more forthcoming and better resources, that's probably the formula that you need to look at.
Could I just, perhaps Mr. Killock could comment on that. There has been some criticism of the fact that the commissioner can only look at a sample of the number of, so the audit trail is incomplete in that sense. Do you think that sampling is of itself okay, but it needs to be at a higher level, or do you reject the process of sampling at all altogether?
I'm sure that I think oversight comes in three or four places, oversight and transparency. The transparency starts with the quality of the law. Do we understand it? Do we understand what it's likely to produce? Then you have a question about authorisation. I don't think political authorisation is the correct way to go about it, because there are too strong vested interests, and it's not clear to the public that is going to be fair and reasonable.
So you think it should be judicial authorisation?
Yeah. Right. Yes, so I think it starts with judicial authorisation, then you move through strong oversight, you have then a need for political oversight, which is a job of this committee, but that I feel needs to be independent. You need to be elected by the Commons, and without vetoes from Prime Minister and so on. It needs to be very clear to the public that you are a creature of Parliament rather than the creature of the Prime Minister of the day. And then finally, we need general information about what the agencies do in broad terms. How many people do they investigate? What size of data do they collect? What kinds of technique do they have at their disposal? Are they able to do face recognition, location tracking, and so on? These kinds of capabilities need a public debate in order for people to agree that they're reasonable things for agencies or whoever to be doing. Particularly, the experience of bulk collection, or blanket collection, being actually occurring without a public debate, I think says that the overall oversight mechanisms have not worked.
Professor Raab, you've given very considerable thought to oversight issues, I know. Would you care to give us the benefit
yes,
of the
Yes, I would. With regard to the commissioners, yes, I do think the resource question is a very serious one, as you have heard from other witnesses. It's also a question, though, of the relationship amongst the various commissioners, the whole welter of them, and how well they liaise when they have to, how well they relate, let us say, also to the Information Commissioner on certain circumstances needs to be looked at. I'm not saying that they don't, but I think that needs to be looked at in particular terms. I think also, and if I may slightly divert to a broader question of the oversight of the intelligence community, two kinds of things. One is there seems to be a kind of lack of technological understanding and capability to understand in the oversight community, as we might think about it. Particularly now when there are so many issues which are not caused by, but involve the use of advanced technologies, whether it's data matching, data mining, the analysis of bulk or blanket data, and so on. I think there needs to be an increasing technological capability built into the institutions of oversight. If you look across to the USA, and if you look at the report which was commissioned by President Obama following the Snowden revelations, a report called Liberty and Security in a Changing World, which I think is a very thoughtful and a very thorough piece of work. Among the things that they recommended was a strengthened agency called the Civil Liberties and Privacy Protection Board to oversee the intelligence community activities, not only for counterterrorism, but also for foreign intelligence purposes. And also another recommendation was that there should be an Office of Technology Assessment created within another board called the Civil Liberties and Privacy Protection Board to assess the intelligence community technologies, the initiatives that are being used within those services, and also to support ways of using technology to protect privacy and not just to invade it. So I think that really is a lack, and if I may say so, it's a lack that pervades parliamentary life as well. It seems to me that there is a shortage of technological capability in understanding technologies almost from the inside. That needs to be brought into play, I think, in the oversight mechanisms and also in the policy process by which legislation is developed and amended in the area of intelligence, in the area of policing and so on.
Sorry, I'm afraid we've still got to have a brief exchange on transparency. Robin, would you like
Just
to?
really, do any other witnesses want to add to Mr. Killock's list of the areas in which there should be more transparency?
Well, I agree very strongly with what Charles Raab has said. I think it's a practical problem which you need to think about, which is that when you're looking at this sort of area, those people were probably going to need DV clearance, and then the population of people who are available have technical knowledge, have DV clearance, and aren't connected with the agencies they're supposed to be criticising or overseeing. And I think that's something you need to address. There may be ways around it. I think it's a very urgent problem to look at.
Any our other witnesses? Any comments on transparency specifically?
I agree with a lot of what's been said, Chair. The only thing is, of course, with transparency, and Jim talked about some techniques, there is that trade-off. We don't want to be so transparent that we tell people that intend to hurt us how we identify them and bring them to justice. So there is a trade-off around that.
I mean, we have a particular tradition with the intelligence agencies that until recently they didn't say anything about anything because that was the culture of the organisations. That is changing. Do you feel, for example, Mr. Killock, do you think that can be taken further and without danger to the public interest?
Well, I think it can, and I think the thing we need to remember here is that the internet is and digital technologies they are a public resource, so people kind of can spot the sorts of things that agencies might be able to do. And I think that what's happened with Snowden is that, 5 years ago, you might say, well, they can probably do this, they can probably do that. And you'd say, well, technically, probably they could, but I doubt that they would, because they wouldn't be so daft or do something so extreme. Now we know what is, or we've got, broad hints. Now people are in the opposite situation, and they just assume that if it's possible, they're investigating it and doing it. And of course, that means a lot of very complicated things, but one of them is that whenever security vulnerabilities turn up, like the Heartbleed bug, the first question on everyone's lips is, were the security agencies aware of this, and were they doing it? And unfortunately, that puts them in a morally dubious situation all the time. So unless it's made a lot clearer where they are really drawing the line, you're going to have a lot of people who are exceedingly suspicious and do not trust these agencies because of problems they start seeing in these publicly available
There is an
technologies.
important point, but there is, I think, to be borne in mind that the agencies do not themselves decide what they want to intercept or what they wish to do. They have to operate within the existing law. And there may be a question as to whether the law itself needs to be reconsidered, but the agencies are not free agents in that sense.
No, but I'm pointing out that the technologies, now the suspicion is that if a technology can be compromised in some way, if there is some gap in the technology that might make individuals vulnerable to criminals or gangs or whatever it may be, then the suspicion is that the agencies also exploit the same problem.
Professor Raab, did you want to say something?
I'd just like to inject what might be an interesting historical note. You can tell from my accent that I wasn't born in this country, although I've lived 2/3 of my life in it. When I first came here, which is exactly 50 years ago, the existence of the intelligence agencies was not acknowledged. What, MI5, MI6, what are they? Who knows? Search me. And every step of the way, when we began to know the names of the organizations, and then when we began to know who ran them, and we began, for goodness sake, to read their memoirs and so on. At every step of the way, it was said, this is the end of civilization as we know it. This is going to damage our capacity for defending national security. Transparency is a kind of incremental development, and it seems to me that with further steps of transparency, one would want really to ask the question, is this really going to be the end of civilization as we know it?
Well, that sounds a pretty fitting way to conclude this session, which unfortunately we must now do. We're in your debt, gentlemen. Thank you for being so frank in the evidence that you've given. It's been a very important contribution to our work. Thank you very much. Order, order.
Portcullis House, the Boothroyd Room. Portcullis House, the Boothroyd Room. Portcullis House, the Boothroyd Room. Portcullis